Live. Okay, go ahead. Do you want me to start?
Oh, you can start.
Okay, hi, I'm Carlet. This is Tozen Daigaku. Today we're going to talk about paid leave, or Yuku Kyuka in Japanese. And so Orren, what do you think?
Hey, I'm Orren Frankham. Yeah, and I'm a junior organizer at Tozen. So, how are you today?
Yeah, pretty good. Pretty good. I've had lots of paid leave, so I'm feeling pretty good.
It's all right for some. Yeah. So, as an organizer, this is what, one of the biggest questions we get?
Yeah, I'd say it does. We get a lot of inquiries, both from members and non-members, about paid leave and their rights. The rights of employees to paid leave. I think it's something that it's a little complicated, but I think a lot of people don't realize that they have a right to paid leave, particularly part-timers and those on 0-hour contracts actually have the right to take paid leave, and it's something that is not well known. So I think a lot of people out there are not taking the paid leave that they have a right to. So that's why this is important.
But aren't we supposed to sort of ignore our paid leave and just focus on the company?
Yeah, and devote your life and energy and spirit to the company like a corporate warrior. That's kind of the sentiment, or was the sentiment. I think that's beginning to change. There still is a big problem in Japan that people don't take their allotted paid leave. And right now, the average paid leave, I think, is about 5 days. And as you'll find out today, and I'm sure you already know, you start after 6 months, you get 10 days allotted if you work 5 days a week. And so people are only taking on average about 5 days a year, when of course they should take all their days because, resting, refreshing your spirit, your body, your mind is good for your health, is good for society. And we got to get rid of this idea that you got to work yourself to death, on behalf of a corporation that really doesn't care about you in most cases. So,
yeah, and especially in this current climate with the pandemic, everyone's a lot more stressed than usual.
Yeah, absolutely. I think there's a lot of stress, a lot of mental stress caused by COVID, both because people losing their job or losing some of their pay, and also because some companies and some workers have a lot more work to do to deal with the COVID pandemic. I know some university teachers complain that doing online classes actually entails more work than in person. And yet there's an image that people who work at home are kind of like having it easy or something like that, when actually nothing could be further from the truth. Yeah, they don't have to commute, but they have to do a lot more preparatory work. There's a lot of stress related to doing stuff over Zoom and other online video conferences. So paid leave, I want everyone to take your paid leave. Even if you don't think you need it, take it. It's important to establish it for everybody, that we all have these rights under Japan's Labor Standards Act. So
how does sort of paid leave in Japan compared to like America?
Yeah, well, the United States, it's, as far as I understand, that I think there's not any guaranteed, like it may differ between the state, but there's no federal guarantee to paid leave. As far as I understand, I'm not a real expert on it, but that's my understanding of it. That is based on the company either gives you paid leave in the contract or they don't. Whereas in Japan, it's guaranteed by the law. A company has no right to refuse. It's the worker's right. And so any contract that says you have less than the guaranteed minimum, that term is invalid. So, how about in the UK?
You are guaranteed paid leave.
Yeah.
Looking at the Gov website, almost all workers are legally entitled to 5.6 paid holiday a year.
Yeah, I think most other rich industrialized countries have that, but US, of course, is really become very, I mean, it's very neoliberal. It's very, the labor laws in the United States are much weaker than I think most rich countries. And that's a huge problem, of course.
So,
shall we start?
Yeah, tell us about paid leave.
Okay, so let me share the screen. Oops, I just, wait, let me share. Wait, how do I do this? Something's not working right. The video thing?
Oh, move this up.
Move this up. Move the whole thing up. Wait a minute. Oh, this thing?
Yeah.
Oh, I see. Right. Okay. Got it. Sorry about that. I'm really bad with IT. So, okay. So, Orren, can you see this?
Yeah.
Can our members see it? Okay. Soon. All right. There's a lag. Okay. So, Tozen Daigaku Yuku Kyuka. That's today's lecture. And we will have questions at the end. So please give me your comments, suggestions, questions, and I'll try to answer them as best I can. Okay, so today we're going to talk about statutory and case law on taking paid leave in Japan. So the full name is Nenji Yuku Kyuka, but it's often shortened to Yuku Kyuka or just UQ because the U of UQ and the Q of Kyuka. Okay, so let me go to the next slide. Okay, Article 39 of the Labor Standards Act, Rodo Kijun Ho Dai 39 Jo. Okay, so here again you see Nenji Yuku Kyuka, and the acronym is UQ, annual paid leave. Okay, Article 39, employers shall grant annual paid leave of 10 working days, either consecutively or divided, to workers who have been employed continuously for 6 months from the day of their being hired and who have reported to work on at least 80% of the total working days. Okay, so this is important. This is a right of workers. And in principle, workers decide when they want to take paid leave. Okay, there are exceptions and we'll get to them later, but in principle, you can tell your boss when you want to take paid leave. Now, I suggest you give them notice if possible, if and when possible, but you have a right to decide when you take them. Okay. So that's something that's very important to understand. And the employer cannot refuse without a very good reason, and I'll get to those exceptions later. In principle, they cannot refuse. They simply have to deal with it, when you take the time off. So again, give notice if you can, and you can just notify your employer. Now, some employers have like special forms or something like that, and I recommend that you follow those guidelines if you can. But the law doesn't say you have to follow the employer's guidelines. The law says you can take them. You can notify your management to take paid leave. But as a strategy, if it's just a form you have to fill out, yeah, go ahead and fill it out, as long as it doesn't say something like I waive my rights to the other days or something like that. So,
can I ask a question?
Sure.
So with this, it's saying at least 80% of the total working day.
Mm-hmm.
So someone who gets ill, or there's some reason why they can't go to work, maybe they get stuck outside of the country or things like that. Does this then mean they are no longer entitled to paid leave?
Well, for that period, like the first 6 months or after that for the year before, between getting tranches, if let's say you're sick for more than 20% of the year or something like that, then there's a prorating system for how many days you get. So you don't get your full allotment. Now that when it says like you're absent, it's like you're actually absent. It doesn't count, if you took paid leave during that time or something like that, of course, that counts as a work day in a sense. So, and again, these are only work days. Like you don't count, it doesn't mean you don't count days that you're off or something like that. Days that you were supposed to work, did you actually work 80% of them or more? And work means work or take paid leave. Now, if you strike, if you're in the middle of a strike and you strike one of those days, that counts neither in the denominator nor the numerator. So just act as if that day didn't exist. So it's 80% of the other days that you were supposed to work. Did you actually work or take paid leave for 80% or more? Does that clear it up?
Yeah. So that means strikes are good.
Yeah, that's what that means. Okay, so let's go on to, let's go further into it. Okay, now, as I said before, even part-timers have the right to paid leave. And this is something really, really important. And what it depends on is how many days a week you work. So first of all, when do you get your paid leave batches, like your tranches of paid leave? Okay, first of all, after 6 months, you see I put here 0.5 years. So after 6 months, if you work 5 days a week, after 6 months, you get 10 days, boom, okay? Then every 12 months after that, so after 1.5 years, after 2.5 years, 3.5 years, you get another batch of paid leave days, another allotment, and the number goes up. If you look at the top orange line here on the chart, see it says kinzoku nensu, number of years of continuous employment. You see there's a 0.5 years, 1.5 years, 2.5 years, 3.5 years, and it keeps going up. So after 0.5, you see it says 10 days. That's the kanji for days, right? And then a year later, you get 11 more days. And then you get it another year later, and you get another 12 days. And then another 14, and then another 16, another 18, and then another 20. Now, once it gets to 20, every year you just get another 20 days. It doesn't increase after that, okay? Now, one thing about paid leave is, let's say after 6 months, you get 10 days. Now, how long do I have to use them? For any allotment of days that you get, you have 2 years to use them. If you don't use them, you lose them, okay? So you get 10 days. If you don't use those 10 days in 2 years, they just disappear. And then the next year you get 11 days. And you can carry them over to the next year, of course, up to 2 years. But after 2 years passes, use them or lose them, okay? So you can actually build up, once you get to 20, you can build up 40 days of paid leave that you have to use before the 2 years is up. Now, if you look further down the chart, you see what the allotment is for people who work less than 5 days a week, okay? Now, if you work 30 hours or more, it just counts as 5 days, even if it's 4 days a week or 3 days a week. If you work 30 hours or more, you get the regular allotment that I just described. If you work less than 30 and less than 5 days, it's based on how many days you work a week, not how many hours, okay? So if you see the top line is 4 days a week, your first allotment after 6 months is 7 days, then 8, then 9, then 10, 12, 13, 13. If you work 3 days, you see all the numbers there. And if you only work 1 day a week, even if you work 1 day a week, you are entitled to paid leave. After 6 months, you're entitled to 1 day. Another year, you're entitled to 2, 2, 2, and then 3, 3, 3. Okay? So this chart is very important if you want to know how many days you should be getting every year of paid leave. And all of this depends on you being employed. So if you're in a freelance contract or what's called gyomu itaku or ukeoi, then you don't have an employment relationship and you're not protected by labor law. So in those cases, you are not legally entitled to paid leave, although some contracts have it and you can fight for it. Okay, so this assumes employment. Okay, so let me go to the next slide. Employer loophole number 1. Now, Japanese, like Japan's labor laws are great in many ways, but the problem with a lot of them is that they have these loopholes and escape hatches for management. And this is one of these for UQ. So Article 39.6 allows your boss to decide when you take UQ. If, okay, so like I said before, in principle, you decide when you take UQ, not your boss. But Article 39.6 has an exception, okay? Now, this exception is basically an exception that allows the employer to designate all but 5 of your paid leave days allotment each year. So the first year, let's say you have 10 days, they can designate 5 of them. Let's say you've been there 6 years or more and you're getting 20 every year, they can designate 15 of those 20 days of paid leave and decide when you take them. But they can't just do it, you know, they can't just do it whenever. They have to meet a certain condition. And that certain condition is a written agreement called a roshikyote that the employer must sign with a majority labor union or a majority employee rep. And a majority employee rep is an employee who is elected, voted for by a majority of the employees in the workplace. Okay, so let's say you're a big company, but your workplace has, you know, 10 employees. Don't count managers, just 10 employees, and 6 of you vote, let's say, for Orren as the workplace rep, the employee rep. Now, the employer must get a roshikyote written agreement with Orren, the employee rep, in order to use this loophole. If Orren refuses to sign it, then the employer cannot designate your paid leave. And in fact, what's really important to understand is that some employers try to make the employee rep think it's just a tiny formality. Oh, could you sign this? Could you sign this? I heard you're the employee rep. So it's not. You're actually giving away all the employees' rights to decide when they take UQ-QCOP. So it's important to really read the documents, any documents, before you sign it. Also, without a roshikyote, it's very important, you decide when. So even during the, if an employer wants to designate certain days, but can't because the employee rep doesn't sign it, the worker can still choose to take paid leave during those days. It doesn't mean that they're automatically work days. What the important thing is, without this agreement, the workers are free to choose when they do it. It here is called the period of the paid leave. So again, if the employer gets this roshikyote, and many companies do, because they don't explain the whole system to their workforce, then they can designate all but 5 of your paid leave allotment each year. Okay. Okay, so let's go to the next one. Employer loophole number 2. Article 39.5 allows your boss to decide when you can take your UQ if ...
Isn't this the same as the previous one?
Yeah, good point. I'm glad you noticed that. It's exactly the same wording. It's another loophole that, and basically the same, a very similar exception, that if the employer meets this condition that I'm about to talk about, again, they can decide when you take it, or at least they can prevent you from taking it when you want to take it. Okay, so what this is if it's recognized that full screen, yeah, is it full screen? Oops, what was that? Sorry about that. Okay, employee loophole number 2. Oh, sorry. Okay, sorry, no technical problems. Okay, so if it's recognized that, let's say you want to take paid leave from March 1st to March 15th. Okay, now if the employer or if it's recognized that that leave would make it impossible for the employer to run the business normally. If it, the wording is if it interferes with the normal operation of the business, then they can ask you to take it at a different period. That's what Article 39.5 says. Actually, same article, different section. Okay. Now, a lot of employers just say, oh, well, it'll interfere with the normal operation of business. They can't just say it. It has to be objectively, rationally, reasonably true before they can do that. And there are court cases that dispute, like when, there's a famous one that I'll talk about soon about what kind of leave would legitimately interfere with the normal operation of business. Now, if you say, okay, 2 weeks from now, I want to take 1 day off, and the employer goes, oh my God, no, we won't be able to function properly. That's not legitimate, because it just means they don't have enough people or they haven't organized the business properly. So a lot of questions about whether it's interferes or not depends on how much notice you give, how it'll affect your business, what arrangements the worker made to try to reduce anti-interference, how long the period is. So again, like I said, if you ask for a day 2 weeks from now, it's going to be pretty hard for the employer to legitimately refuse and to say you have to take it a different time. But if you say, hey, boss, guess what? From tomorrow, I'm taking a month off, paid leave. And, and you're in the middle of a huge project that's just about to start. And, the boss is like, oh my God, what are you talking about? I'm not going to be able to function. Then they might be able to get away with refusing and forcing you to take your paid leave at a different period. Okay. So there's no clear line about what constitutes interference with the normal operations of the business, but the hurdle is reasonably high. It's not just the employer can just say whatever and get away with it. And I'm going to talk about a specific court case now. This is the most famous court case regarding paid leave in Japan. Now, I'm going to do a spoiler that our side lost the case. Okay, the worker lost the case in this court case, and just to show that I'm no Pollyanna. Yeah, I mean we don't win everything, we don't win all the time, but I think it's important to read the cases of when our side lost, when the worker lost, just to really get a clear understanding of the boundaries and the borders of how these laws are interpreted. So I thought this, and because this is so famous, I mean every labor lawyer would know this case. I thought maybe, yeah, let's go into it. Okay, so what you're seeing in front of you, the English, is actually, I translated actual analysis of the actual case. Okay, in this case, the verdict came out in 1989. Okay, so the right to take annual paid leave entails the relief from the duties to go to work on the days during the period, the start, end, and total days of which are decided by the worker, as per Article 39.1. The Supreme Court said this back in 1966. Okay, so what this means is that when a worker says, I'm going to take such and such days off, and I want them as paid leave, the employer is required to try to comply with, comply with it and let her take those paid leave days as she wants. The employer is required to make basically like their best effort and to give due consideration and to try to work out a way that she can take the days that she wants. Okay. But again, there are situations where they can refuse and force her to change the period of her paid leave. Okay. So at the bottom, you see, if it can be established that granting leave during the period designated would interfere with the ordinary running of the business, then exercising the right to change the paid leave period is legally acceptable. So this is the right of the employer. Management has the right to change the paid leave period. But again, it doesn't mean that they can just do it whenever they want. They have to have legitimate reason and show that it'll interfere with ordinary running of the business. Okay, let's continue on this case. Okay, so some of this is quote from the actual verdict. When a worker tries to take paid leave over a long period, the worker must make prior arrangements. And when they say long period, we're talking like 2 weeks or 3 weeks or 4 weeks or something like that. The worker must make prior arrangements. And if the worker does not, then it must be acknowledged that the employer has some degree of discretion regarding exercising the right to change the paid leave period. This is called Jiki Henkoken. Maybe, oh, sorry. This is called Jiki Henkoken. That's the right to change the paid leave period. But the employer has some discretion, but it must be reasonable and rational, or what's gori teki. And we often talk about gori teki. So this is another example of that. Now, the longer the period the worker wants to take as paid leave, the greater the difficulty the employer will have finding cover, the greater the likelihood that the leave will interfere with ordinary operations of business. And again, this is just kind of like common sense, that if you're in the middle of a big project and you suddenly announce that from tomorrow you're taking 6 weeks off, it's probably going to interfere with the ordinary running of the business. So what I would say is that if you're going to take long periods of leave, try to give more notice than if you're going to take, just a couple of days or something like that. So it is difficult to predict accurately the volume of work at the workplace of the worker during their long leave period, the possibility of finding cover during the period, the number of workers planning to take off during the same period, and other issues related to ensuring ordinary business operations. Now, cover is a very important issue. So some jobs, when the person is not there, there must be someone covering their job. Like teachers is a great example. If there's a class scheduled and the teacher's not there, they need to have a cover teacher or a substitute. So if every time a worker asks for paid leave and the employer says, no, we don't have any cover, we don't have enough teachers, that's on them. That's on the employer, because they're not hiring enough teachers to have that kind of flexibility that, someone able to cover when someone's out, because it's natural people are out sick, people have a right to take paid leave. So the employer has to hire enough people so that their employees can take paid leave and in fact take their entire allotment of paid leave. So that's something really to consider. However, there's other things, like depending on what's going on at the workplace, that it might be considered reasonable that the employer makes you change the timing of when you take paid leave. Okay. So the court says, but considering that we must determine whether the leave caused interference to ordinary business operations and that the worker in this case did not make such arrangements, we must acknowledge a degree of employer discretion to exercise the right to change the period of leave. Now, in this case, the court found for the employer, what happened was the employer, I'm sorry, let me explain the GG Press case. The employee said he wants 4 weeks off. And there was very little notice given and no arrangements were made. So the employer said, okay, look, we'll grant you the first 2 weeks, but the second 2 weeks, the second half of that period, please take some other time. Now the worker took the 4 weeks anyway. And then the GG Press, I'm sorry, the worker is a journalist, by the way. So the journalist wanted 4 weeks off and made no arrangements to cover his work during those 4 weeks. So the GG Press said, you can only take the first 2 weeks, the next 2 weeks you have to change. But the journalist took it anyway. And then GG Press gave some kind of like reprimand or some kind of disciplinary process. I forget exactly what it was. And the journalist sued in court. And the court said, no, this is in 1989, the court ruled in favor of the employer, that the employer was just to refuse to grant the last 2 weeks in that particular timing. Okay, so of course that was a loss for the worker. Okay, and so that's it. So now can we take questions and answers?
So far we've got no questions.
Okay. Yeah, maybe it's all of a sudden, and so now that I said questions, answers,
Yeah, so far we've got nothing in the chat.
Okay.
But
If you want
just to check,
Mhm.
so with the paid leave,
Mhm.
it's all sort of like the paid leave days, it's cumulative.
You mean like the when you get 20 days in a particular year?
Yeah,
You carry them over to the next year.
yeah.
So you can add 2 years worth, but then if you don't use an allotment after 2 years, those disappear.
So then it becomes, so you have 40 for sort of 1 year, but if you don't do that, use them all, it drops back down.
Right. So you have, let's say you get 21 year, you don't use them. Then you get 20 the next year and you don't use them. Then after the second year, you'll lose the first 20 because 2 years have passed and you only have 20 left.
Yeah.
But then you'll get another 20. So you can't end up with 60.
Yeah.
Unless your employer grants you more than 20 days.
So we've got a question, will we be covering parental leave?
Yeah, so like parental leave, maternal paternal leave is a completely, like it's a different type of leave, paid leave. It's also paid not by the employer, but by the system. So it doesn't fall under UQ. Of course, mothers and fathers have a right to parental leave as well as childcare leave after the baby is born. Well, I should say mothers and fathers have a right to childcare leave. So the mother has a right to the, like it's 6 weeks before and 8 weeks after the expected date of arrival of the baby. And then afterwards, the childcare leave, both mothers and fathers are eligible for that, but that's not considered a UQ.
We are also going to be covering this in our next Tozen Daigaku.
Oh, we are? Okay.
Yeah, maternity and paternity leave.
Okay, great.
Which will hopefully be hosted by Hifumi and Kato Sensei.
Great. Yeah.
If Kato Sensei has any free time.
Yeah, right. We keep her very, very busy. So.
Yeah. Okay. So with excuses employers give for not granting paid leave or things like that, what are kind of like the most common things? Like,
well, I mean, well, of course, the biggest one is that they use that article in 39 that says 39.5 that says it's going to interfere in the normal operations. And if they don't know much about like the case law or something like that, they might think they can just say that. And because even if it mildly inconveniences them, they think that that applies. I think that's the most common excuse I get. And of course, many companies try to set up the Rosh Kyote with an employee rep so that they can designate most of the days that the worker gets. So in terms of interfering with operations, excuses, very common excuses are we can't find cover. Like if it's a teacher, we can't find someone to cover. Another excuse is you didn't give enough notice and we have to make all kinds of arrangements or something like that. And also another thing is that employers often ask why you want to take paid leave. And it's very important to know that you don't have to say why. You don't have to give a reason. I mean, if you want to, you can, but there's absolutely no obligation. You can say, I want to, lie on the beach, or, I want to be lazy all day. This is why I put the picture on the first slide. If you let me go back to it. These two. This is totally fine way to take to spend your paid leave. It's your day. It's often called in English personal days and stuff like that. You can do whatever you want. You don't have to have a particular reason or anything like that. So.
Okay. Another question in chat. Are there legal standards for negotiating time off after all paid leave is used up? For example, illness, but all 10 days are used.
So if you've already used your allotment and you're sick, like the law doesn't require employers to recognize paid sick days, anything outside of the normal paid leave, Yuku Kyuka. So it depends on your contract and the work rules, or the Shugyo Kisoku, right? So if there's nothing in the work rules or contract that says you get sick days, like paid sick days, then all you have is negotiating. So like, yeah, if you unionize and you can negotiate to recognize sick, paid sick leave, but it's not guaranteed in the law at all. Does that answer the question, do you think?
Yeah, I think so. Another question. How much is enough notice?
Yeah, I mean, like everything else, there's no clear number.
Just goriteki again.
It's goriteki again, yeah, reasonable, rational. But what I would say is a key point from this court case is that you have to look at all the factors. Like, first of all, the longer your paid leave, I would say it's reasonable to demand try to give more notice. If it's just one day, I think I'm not 100% sure, but I recall a court case where someone gave a day's notice for 1 day paid leave, and the courts accepted that. But, you know, I'm not 100% sure, and I wouldn't rely on that totally. But because also it depends on this other situation. Like, are you in the middle of a project where you're the key figure, and like if you suddenly take off, you know, everything is going to go to hell? Well, then maybe it's, you know, you should give a lot more notice and try to make arrangements so that your absence is not going to really devastate the company. I mean, a lot of employers, it's just nonsense and they just don't want to recognize paid leave. Just remember, but just try to think of what how much you'll inconvenience them. So yeah, if it's a month, I would give a lot more notice than if it's 1 or 2 days.
So earlier you said about when taking sort of like a lot of paid leave, it's kind of moves on to sort of the employee to try and find the cover and try to sort of make sure like the company can run smoothly.
Well, that's what the court said, like make some kind of prior arrangements. Like, it's not that it's really the employee's responsibility. It's just that the employee can't be like, oh, tomorrow I'm taking 6 weeks off. Good luck. I don't care. You know what I mean? Like the employee has to take reasonable or make reasonable efforts to arrange something. Like if they have to hand over an important report, they should hand it over. They should talk to employees about what they'll need to do while they're out, right? So if you're going to take 6 weeks, yeah, talk to your employees about, okay, you know, next month I'm taking a 6-week paid leave vacation. So during that time, I need, like, I normally would have to do this, and this for this project. So can you do that while I'm gone? Like, the more the worker does that, the more difficult it'll be for the employer to legitimately refuse. Of course, ultimately, it's the employer's responsibility to make sure the operations run smoothly.
So kind of following from that, if an employer refuses an employee's leave, how much, or does the employer have to sort of give alternate dates or do anything else to try and help work around it?
If they exercise the right to change the period, like Jiki Henkoken, if they exercise the right to change the period, and if it's legitimate, then they can propose. They can't force the worker to take it at those other days, but they should. It's considered more acceptable if they propose other dates other than that period. Okay, and if the worker thinks that the employer is illegitimately refusing, then in many cases we recommend that the employee takes the paid leave. Like, let's say it's like next month I'm taking 1 day off on February 3rd or something like that, let's say, right? And the employer says, no way, you can't, because it's going to interfere with operations. Say again, I'm taking it on February 3rd, and then take it. And then the question is, if the employer doesn't pay, then, you know, there's an unpaid wage case. If they discipline you, then it's an unfair discipline case. But again, you have the right to take it. It's not your employer giving you that right. The law gives you that right. So.
Okay. So we've got a situation here. An employer assigns an instructor to a client who requests that the person assigned cannot take paid leave during the assignment. The employee doesn't agree and indicates they want to take leave, but they are assigned to this something, to this client. Can the employee take leave?
Okay, well, again, assuming that it's an employee relationship with you and your employer. Okay, so you have an employment relationship with your company, and the company sends you to a certain client, like it could be a dispatch company or something like that, sends you to a certain client. Now, if the employer and the client, they may have some kind of contractual agreement, but that doesn't replace the law. The law is the employer is responsible for recognizing your right to take paid leave. So, you know, I would say they shouldn't be making an agreement with the client to violate your right to take paid leave. In the same way, you know, if they may have agreement with a client to only pay you less than minimum wage, but of course that's not a valid, that doesn't trump the labor standards law. So, and again, the same thing applies. You have the right to take paid leave, whether you're at a client or not, wherever you're working, with all the other factors that we discussed today. So.
Okay. So a third party couldn't sort of dictate.
Yeah, a third party, again, is not your employer. Like the situation at the third party could be important things to consider about whether the employer has a right to refuse, but the third party cannot dictate conditions to the employee. The employer and the working conditions are between the employer and the employee. So a third party or something like that, even in a dispatch relationship where the third party is the one giving work orders, they still can't decide working conditions for you, which includes paid leave.
Cool. So there are, within labor standards law, there are certain jobs where exceptions are made, like for maybe other laws. Things like a civil servant. Are there any exceptions in regards to civil servants?
Yeah, well, there are certain categories for which Labor Standards Act does not apply. There's certain categories of workers. So civil servants is one of them, especially national civil servants. If you're an employee of the national government, a whole different set of laws apply. Labor Standards Act does not apply. That's what that's the way the law is set up. It's clearly the general labor laws do not apply. Also, if you're a domestic servant, like a housekeeper, Labor Standards Act doesn't apply. And I've read, I'm not 100% sure, but I've read that the USGIs have domestic servants and they put a lot of pressure to not make them covered by Labor Standards Act. Labor Standards Act was enacted in 1947. And of course, that was during the military occupation of Japan. And so apparently, you know, US like military brass or maybe other rich people in Japan or something like that, of course, they don't want themselves to be subject to these laws like Labor Standards Act. So it's really frustrating because domestic servants and housekeepers and all like that are probably the people who need it even more than normal workers. They need that protection, but they're considered to be not protected by Labor Standards Act. Yeah, also, I mean, yeah, it probably doesn't come up much, but if you're on a ship, like a sailor or like marine industry, like everything is different on a ship, right? Like you can't go home and stuff like that. So there's special laws for people on ships, and that does affect like your work hours and paid leave and all that. So That's the only ones I can think of. There might be other exceptions, but
yeah, in a lot of the acts you see, it's included like mariners.
yeah,
are not
mariners.
eligible.
That's what I was looking. Mariner workers or whatever like that. Yeah, and of course, again, if you're not in an employee relationship, if it's gyomu itaku or some kind of outsourcing or freelance, you're not protected by Labor Standards Act.
Jerome in chat has put local civil servants paid leave is determined by local statute.
Yeah. Apparently.
Okay.
Yeah.
So with the whole, the employer can dictate up to 5 days of your paid leave.
Oh, but 5 days.
All but 5.
Yeah,
Yeah.
yeah, yeah.
When this was first implemented, wasn't it treated as this was going to be a great thing to get workers to take their paid leave, or?
Oh, yeah, that's a different law more recently about that they can even designate the last remaining 5 days. This is supposedly something for workers. This is, Abe's series of workplace reforms. One of them was that an employer must force employees to take at least 5 days of paid leave per year. In other words, they get much more, and they don't have to force them to take all the days, but they must force employees to take at least 5 days a year. And this sounds like really good because it sounds like it's for the employee. But like many of the workplace reforms, it's actually not for the employee. Because what it means is that up until the time that this law came into effect, the employer could only designate all but those 5 days. And now they can even designate those 5 days. In other words, under the guise of making sure that people take their paid holidays, they can force you to take the paid leave and then you're done. So what this is that, and another thing that makes it clear that this law had malintention is because when the law was passed, the average number of paid leave days that workers took was 5. So if that's not the problem was that they only took 5. So it seems clear that the intention of the law was just to give employers even more control, and pretending that it's for the workers, the employer can force. It doesn't say that they have to wait until the last minute before you lose the days. It doesn't say when they can do it, but it's saying they must force you to take 5 days. So if they put it together with the Rosh Kyote, the agreement with the employee rep, and then they force you to take those 5 days, basically the worker has no more ability to take days freely. So.
Thank you. So going back to the Rosh Kyote and the designation of your paid leave, if a Rosh Kyote isn't signed and a company wants to have sort of like a Rosh Kyote in place, can they sort of keep sort of having sort of Jugyo and Daiho elections to get until they get what they want, or?
Yeah, I mean, that's something I think that hasn't been going in, hasn't really been taken up in the court, something like that. Yeah, I mean, some employers really try to force workers to sign a Rosh Kyote agreement and to get that agreement so that they can designate paid leave. And then if the elected rep refuses, employers sometimes have new elections and try to keep doing that. My sense is that if it went to court, it might be considered not democratic, and the employee rep elections must be democratic. So if the employer doesn't like the employee rep and then just keeps having elections until someone they like gets elected, it's obviously not democratic, and if it goes against the clear spirit of the law, that it must be the agreement of someone who represents the majority of the employees. So I'm just guessing that, though. I haven't seen any case law specifically about that yet.
Okay. Another situation. So, employee has a guaranteed monthly salary. The employee takes leave during the month. Paid leave is used, and those days are paid. So, monthly salary is not reduced.
In principle, yes. Okay. Yeah. There's a. I mean, I almost don't want to talk about it because there's actually a way that employers might be able to pay less, but maybe I shouldn't talk about it. I mean, yeah, in principle, yes, and that's usually what happens in almost every case I've seen. If you're on a monthly salary and you take a day of paid leave, like you should just get your salary as normal. So unlike if you're sick, you might not get paid, or if you just don't show up for work, you won't get paid. If you take a paid leave day, basically it means it's the same as if you work that day. Okay. And contact me directly if you want to know the exception that I'm worried about.
And then to continue, employee work value exceeds the guaranteed amount.
Say it again.
Okay, so okay, I think this is all one large point. So the employee has a guaranteed monthly salary.
Yeah.
Employee takes leave during the month. Paid leave is used, and those days are paid. So monthly salary is not reduced.
Right.
Employee work value exceeds the guaranteed amount.
The employee work value? Say it again.
Yeah. So that's just how it's put. Employee takes paid leave, but not paid because employee says the payment would be extra.
Wait, say again. So the employee takes paid leave and then isn't paid for that day? Is that what it means?
I think this might be bonus related. So maybe overtime or bonus related, like if you're working overtime or you're working, like you get a bonus for the amount of hours you work, or
I think it's basically that you get paid like you're normal if you had work. So I'm not sure about if bonus is calculated, and I always forget that. Let me check. Hold a second. Yeah, I mean, in principle, it's what you normally would have been paid. Let me check. Okay, let me erase. So is the question like, is bonus included or in calculating it?
it's not
Okay.
but we've got a second question, I think, that does cover this point. Many companies provide a bonus on top of salary. Can they reduce a bonus based on sort of paid leave amount?
No, you can't use the law to reduce conditions at all. So if you take paid leave and they pay you, they can't take it out from somewhere else. So sometimes it's hard to prove, like if the bonus is not clearly explicit in the contract, if it just says, well, we might pay a bonus depending on how the company does, they might punish you by paying less bonus if you take a paid leave. So then you have to prove that they did it because you took paid leave. Like let's say they paid a lower bonus to everyone who took paid leave, but paid a higher bonus to those who didn't. That might be a clear pattern that they're violating your right to take paid leave. They cannot in any way penalize you for it. Does that make sense? You understand what I'm saying, right?
Yeah. So, for example,
they can't mess with you that way, right? You know what I mean?
So, for example, some companies have sort of like a maximum amount of hours, which is below sort of what is considered like full time, or like the 30 hours a week.
Right, like for Shikoku enrollment or something.
Yeah. So you're working, or you're supposed to be working 29.5 hours a week. And they say, oh, if you're averaging over that for the quarter, we'll give you an extra however much.
Yeah. Oh, that wouldn't be a bonus. I mean, that's overtime pay. That's clearly overtime pay. I mean, if they call it a bonus, they're just trying to make it sound like they're giving you something great. If you go over your stipulated work hours, then they must pay you overtime pay.
And can sort of paid leave, like if you take paid leave, is that accounted for when calculating overtime? So if you take 1 day of paid leave, are the hours then deducted from what would be the total for the month?
Yeah, like when you take paid leave, when you're calculating average hourly pay or something like that, consider paid leave to be a regular work day that you worked. And remember, your coworkers did work. So it's not the same as if you're sick or you're out. So it's just as if you worked in terms of calculating wages. Does that help?
Yeah.
I hope.
I think the only time it becomes then a problem is companies where sort of daily hours are varied.
Yeah, well, I mean, well, because it's an average, that's why that handles that, right? Like you go through, like you calculate a yearly average, and then that, averages out all the different, discrepancies if you work a little bit one day and a lot more the other day, right?
Yeah. Okay. I think this is clarification on the earlier point. So you have a guaranteed monthly salary as well as payment for each class you teach or each class worked. If the total classed work amount exceeds the guaranteed salary, the company will not pay the paid leave.
Wait, say it again. Can you say it one more time? I'm trying to understand.
Okay. So the employee has a monthly guaranteed salary,
Right.
as well as sort of each class they teach, they get sort of an extra payment.
Each class they teach on top of the outside the contract, you mean?
So they've got monthly salary,
Mm-hmm.
and the number of classes is also then added on top.
So if like a weird system, like they get a certain amount guaranteed, and then on top of that, that's interesting.
Yeah.
Yeah. Well, first of all, paid leave, when you calculate paid leave days, there's 3 different ways to calculate it. And one of them is just your normal pay, not counting overtime. I'm not sure how that would work out. And that's an unusual system where there's like you're guaranteed, like, so even if you do no classes, you still get a certain amount of money, right?
Yeah.
Yes. So yeah, so one is like your average daily normal pay for normal hours, not counting overtime. Another is you take the past 3 months, you total this past 3 months, and then divide it by all the calendar days, which will put it a little bit lower, right? It's called Heikin Chingin, average, right? And then the third is you use the standard day wage that's used for shaka hoken, like kenko hoken. So in that case you described, I would say like, yeah, I mean, you mean like, so some days they taught more classes, some days they taught less, but then just it's all on top of the basic salary? That's an unusual case, right?
Well, you put the company, if you want to know.
Yeah, I'm okay with it.
Out education.
Yeah.
So yeah.
So they have a basic guaranteed salary, even if there's no classes, and then each class you get extra.
Yeah. But if your classes or payment for the classes exceeds the payment for like a daily wage, if you take paid leave, then
it's like a
they don't
draw.
pay the paid leave, they just pay for the classes.
Yeah, that sounds illegitimate. I have to look at it really carefully to make a decision about it. And of course, the court would have to decide, but it sounds like they can't do that. Like, that sounds like a draw system. Like sometimes people work in commission have a draw system. And so they're trying to, in other words, if the contract says we will pay you this amount for these classes, and it goes over the daily, oh, I see, that's like a daily minimum guarantee, and then you might be able to go over it. They can't use that money that took you over to and say, we already paid your paid leave, right? The paid leave is a separate thing, as if you worked that other day. So it's another day that they have to at least guarantee whatever it is they guarantee, and in fact, the average, okay? I think I understand now. Yeah, so there's a minimum guarantee, but then if you teach a bunch of classes, you'll go over that minimum guarantee, you get more. And that excess can't be used to claim that we paid your paid leave. You see what I'm saying?
Yeah.
Paid leave is getting paid for not working.
Yeah.
So that the way you describe it sounds like that they're paying just for work that was done, for classes that were taught, right?
Okay. Oh.
Yeah, paid leave is important.
And we've got the explanation for it.
Is that paid leave, you get paid for not working. What did you say?
So here we've got the contract states a guaranteed monthly salary.
Yeah.
With the option to work overtime. So it's possible for the monthly salary to be higher than the guaranteed minimum salary.
That's very common, yeah.
And then the company has recently stated that if the person takes paid leave during a month when they have earned more than their guaranteed minimum, then they are under no obligation to pay for the paid leave that's been taken.
That sounds like nonsense to me, unless I'm missing something. Like that when you go over your contracted guarantee, you're getting paid for work that you did because you did more work than the guarantee. So they're paying for work. The paid leave is they're supposed to pay for you to, do whatever you want and be lazy. Do you see what I'm saying? So that sounds, if I understand it correctly, that sounds absolutely illegitimate and illegal. They must pay for the day off. And they can't have some kind of system where, if we paid you a lot here, we'll use some of that to pay your paid leave. You see what I'm saying? I mean, it goes just like, let's say you work on Monday and you work on Tuesday. And they say, well, we paid you Monday, so we're going to use that money to also pay you Tuesday. That's basically what's happening, right? No, Monday pay was for Monday. Tuesday pay is for Tuesday. So whatever they paid you Monday, they can't use some of that to pay for your paid leave on Tuesday. Is that clear? I hope.
I think so, yeah. Like they can't sort of divide up.
Yeah.
Yeah.
I mean,
how it suits them.
They're trying to fulfill two different obligations with the same money, right? So
yeah,
if I'm understanding it correctly, then that's definitely illegal, and that means there's unpaid wages, and they still have to pay it. So
yeah. There's also, I think, in Article 39, there's mentions of hourly paid leave.
Hourly paid leave?
Yeah.
That you also need an agreement for that. You need another Rosh Kyote between the employer and the employee rep that you agree that you can divide paid leave up into like hours. So I'm going to take 3 hours paid leave. And again, they need that Rosh Kyote before they can do that. So in other words, if you have 10 days, we can calculate it maybe as 80 hours or something like that. You know what I mean? And then take 7 one day and 2 the next day. Sounds really complicated to me. And I don't know many employers who do that because it sounds so complicated. And a lot of places they allow half days. So I've never seen anything more broken down beyond half days. Like that is kind of common that people take half days off.
Yeah. Yeah. If you've got any other questions in relation to that, please email us at info@tozenunion.org.
Yes.
And I put that in the chat. Yeah, especially with sort of how the company's trying to use your paid leave or your overtime pay to pay your paid leave. Okay. Do we have any other questions? Oh, Berlitz offers half days.
Yeah. Yeah, that is pretty common. Yeah, and often workers are happy because sometimes they want half days. So. You know, like often people have like an errand or something and they want to take half day off but not the full day off. So.
Would that fall under things like if you have a doctor's appointment or a hospital appointment, you can then book the paid leave?
Well, remember paid leave, you don't need a reason. You know, paid leave is, again, you can be lazy. You don't need any reason to take paid leave. Now, it might be a factor if you suddenly need 2 weeks off and you only give a couple of days notice, like maybe you're really sick or something like that. But you don't need to explain the reason or justify paid leave. You would have to justify unpaid leave, strangely enough. Like a company doesn't have an obligation to grant you unpaid leave. You get what I'm saying?
Yeah.
So yeah, if you had to take unpaid leave for an errand or something like that, and you don't have any paid leave days, or you don't want to take paid leave, yeah, then you'd have to get the agreement of your employer to take an unpaid leave day off. And even paid leave, employers think it's up to them to grant you paid leave or not. And it's really important to understand that it's not the employer, it's the law that grants it to you. You know, some people, I've heard people say, oh, my place, they don't allow paid leave. It doesn't matter what they allow or whether it's in the contract or the work rules. It's a right guaranteed by the law. So,
with things like unpaid leave, like due to sickness, so like if you don't have Shakai Hoken and your company has no sort of sick leave preparation, and your doctor says, oh, you need to be off for this amount of time.
right.
But you've also got some paid leave days. However, like you don't necessarily want to use them. Can your company tell you you should use them, or can they?
I mean, they can't order you to use them because, again, it's up to the worker to decide. So, yeah, they can't force you to take paid leave. You can take them as unpaid leave. However, depending on how long you're out, like if you're sick and you're out for like, 2 years or something, of course, the employer would probably get away with firing you, right? So it depends. Like there might be rules about when you're sick, call the company by such a time, and there's all these like little circumstances, and it has to be gori teki. So if you're suddenly sick in the morning with a fever and you call and say, I'm sorry, I can't come in, they can't really fire you or discipline you for that. And they can't make you take that as a paid leave, because a lot of people want to save their paid leave for like a certain thing, right? A lot of employers try to, or they automatically count it as a paid leave and pay you. But just remember, it's really important, if you don't want to take it as paid leave, make it really clear, you don't want to take a paid leave. And if your employer tries to force you, then, come talk to us.
So there's also things like, what is it? Like the amounts. Is it, well, things like 2 days off a week. In Japanese law, that's still treated as like, or worded as holiday.
Oh, the 2 days a week. Well, the law stipulates that you have to have one hote kyujitsu, meaning one official day off per week. Official. Yeah, I mean, usually it's 2 weeks, of course, but I mean, actually, a lot of companies, people work 6 days or even 7 days. And what that means is if it's a hote kyujitsu, a legally designated day off a week, then if they make you work on that day, they have to pay you 35% overtime rather than just 25% overtime rate. Okay. It can be 1 day a week or 4 days every 4 weeks. So that's called hote kyujitsu. I mean, how these words are translated, like different employers translate them in English different ways. So it's really important to go to the Japanese as much as possible.
Okay. Any further questions? Or any final comments from yourself, Lewis?
Everyone should take your paid holidays, paid leave, and of course, you know, build up your union so that you can make sure to protect these rights, because the rights, you know, the rights are only going to be as strong as we protect them. So.
Yeah. Okay. So I think that seems like we are coming to an end.
Great. So please look forward to Kato Sensei's paternity leave thing, right? Tozen Daigaku.
Yep.
And I guess Hifumi too. So, and thank you very much. Please share. And what's it called? What do you young kids say? Like and subscribe.
Like, comment, and subscribe.
What? Say again?
Like, comment, and
Yes,
subscribe.
so please like, comment, and subscribe. Okay. Thank you very much.
Thank you, everybody. And yeah, our next one will be in February. See you soon.
Bye-bye.